Further judgment in the appeal, Coventry and others, and Lawrence and another.
This judgment is a follow-on to the Supreme Court's judgment in Coventry and Lawrence, 2014 UKSC 13. The Supreme Court there held that the occupiers of a speedway, stadium, and racing track were liable in nuisance to the appellants, who were claimants at first instance, who owned and occupied a residential bungalow, fenland, some 850 yards away. The court in that respect restored the first instance judge's order for an injunction with liberty to apply to vary its terms, and the order for damages and costs which the Court of Appeal had overturned. The appellants also sued Mr. Terence Walters and his son James as landlords of the stadium or track at the relevant times. The judge exonerated them on a basis which can now be seen to be mistaken, and the Court of Appeal did not need to deal with their position in detail, since it held that there was no nuisance at all. By the time of the trial, Fenland was unoccupied due to a fire, and it remains fire damaged and unoccupied today. The questions now arising are, first, should the injunction be suspended until Fenland is rebuilt? Second, when should an application to vary the terms of the injunction be permitted? Third, are the landlords also liable to the appellants in nuisance? And fourth, does the order for costs against the respondents infringe Article 6 of the European Convention on Human Rights, which protects the right to a fair hearing? Lord Neuberger gives the main judgment. All members of the court agree that the injunction should be suspended until Fenland is fit to be occupied, unless at some future date it is shown that suspension is preventing restoration. Any party should also be free to apply at any time to vary or discharge the injunction. Lord Neuberger, with whom Lord Clark and Lord Sumption agree, holds that the claim in nuisance against the landlords must be dismissed on the ground that the landlords neither authorised nor participated in the nuisance. Lord Carnworth, with whom I agree, would have held that the landlords participated in and were consequently liable for the nuisance. Lord Neuberger, Lord Mance, Lord Clark and Lord Sumption hold that the issue whether the judge's order for costs infringes the respondents' rights under Article 6 of the Human Rights Convention must be adjourned for a further hearing after notice is given to the Attorney General and the Secretary of State for Justice. As the question of landlords' participation, the court's reasons are that the law relating to the liability of a landlord for his tenant's nuisance is tolerably clear in terms of principle. To be liable, the landlord must either have authorised the nuisance by the basis on which the property was let, or must have participated directly in the commission of the nuisance. Here there was no question of the landlords having authorised the nuisance. It was not an inevitable or nearly certain consequence of the letting of the stadium or track. It is clear that those uses could have been carried on without causing a nuisance. As to participation, the question whether a landlord has directly participated in a nuisance is largely one of fact for the trial judge and turns here on what happened after the grant of the leases. In the view of the majority, the factors upon which the appellants rely are not sufficient to constitute participation in the nuisance. The final issue of costs is of general importance. The successful claimant's costs at first instance had three components in the light of the Court and Legal Services Act 1990 as amended by Part 2 of the Access to Justice Act 1999 and in accordance with the civil procedure rules. First, base costs, that is what their lawyers charged on a traditional basis. Second, a success fee, to which the statute and rules entitle the lawyers because they were acting on a conditional fee, no win, no fee basis. And thirdly, an ATE after the event insurance premium payable to an insurer who agreed to underwrite the potential liability of the claimants to the respondents for costs if the claimants had lost instead of won. The claimants' base costs were £398,000. The success fee was approximately £319,000, and the ATE premium was around £350,000. As a result of the judge's order that the respondents pay 60% of the claimant's costs, The losers are potentially liable for over £640,000 out of a total of around £1,067,000 costs. Even ignoring the success fee and ATE premium, the fact that it can cost two citizens, that's the claimants, £400,000 in legal fees to establish and enforce their right to live in peace in their home is highly regrettable. The addition of a success fee and the ATE premium add very greatly to the respondents' exposure. In the light in particular of decisions of the European Court of Human Rights in Dombo Behir and Netherlands 1994 and MGN versus United Kingdom 2011, the Supreme Court now considers that the respondents may be right in their contention that the resulting liability for costs would be inconsistent with their convention rights. But that if so, then, contrary to the appellant's submission, the problem may lie not in the secondary, but in the primary legislation governing such costs. In relation to litigation under conditional fee arrangements made since April 2013, the legislative scheme has now changed, but the problem remains live in its full width in this case, and no doubt in relation to other litigation brought under arrangements predating the April 2013 change. In these circumstances, it would be wrong to decide this issue without the government having the opportunity to address the court, in particular on the question whether there is any incompatibility and whether it is in subsidiary or primary legislation, which would call in the latter case for a declaration of incompatibility rather than a striking down of the legislation. Accordingly, if the respondents wish to maintain their convention that Article 6 is infringed by the costs order, the appeal should be relisted for hearing before the Supreme Court after appropriate notice has been given to the Attorney General and to the Secretary of State for Justice. The Court is adjourned.